What pleas and penalties occur in your Avon Lake court?
As far as pleas, there's 3 pleas in all courts, and that is guilty, not guilty, or no contest. Guilty is an admission of your guilt. Not guilty is I'm not guilty and I want a pretrial or a trial. And then no contest is similar to guilty, but it's not an admission of your guilt, but is an admission of the truth of the facts stated in the complaint. It can't be used against you in any subsequent civil or criminal proceeding. So that's the language of the rule.
Okay. What about penalties?
Penalties, as I indicated, range. There's the misdemeanors, first, second, and third degree, and then minor misdemeanor. The definition of a misdemeanor is a charge that has a maximum penalty of 180 days in jail. So 6 months in jail is a misdemeanor. Beyond that is a felony. The municipal courts don't litigate felonies. That's the responsibility of the Common Pleas Court, which is each county, 88 counties have a Common Pleas Court. It's county-wide, and again, there are certain criminal offenses that are felonies, and they automatically go up to the Common Pleas Court. I'll go through the levels. The misdemeanor of the second degree, $750 fine maximum, 90 days jail. Third degree, $500 fine, 60 days jail. Fourth degree, $250 fine, 30 days in jail. Minor misdemeanor, no jail, $150 fine, maximum penalty. There are some community service levels that apply to each, meaning the court, as opposed to imposing a financial penalty, you can order that they do community service. And so those are the levels of penalties for misdemeanor cases. The court also has the authority to be creative, and so even though the statute puts these limits on these levels of misdemeanors, they also provide the judge with the opportunity to impose the requirement that people get treatment. So a lot of the cases we have are alcohol and drug related.
Okay.
So the court can order as a part of probation. So we impose jail and suspend the jail on condition. And these conditions are all these things that the court can do to try to help the situation.
Right.
Whether it's, having them assessed for alcohol and drug issues and then following through with the treatment recommended by the experts who make the assessment.
Yeah, you want the best for the.
Right. I'm trying to improve these people's situation, and you really have the opportunity to help people. And let me move on to. You asked before. Well, what are the usual cases that we deal with? One of the more usual charges that all municipal judges in Ohio deal with are driving under suspension. There's like 50 ways that someone can lose their license and have it suspended. The biggest one probably is when you're pulled over by a police officer for a traffic stop, you have the responsibility to show that you have insurance. And if you fail to show that you had insurance, it'll be noted on the ticket, and it'll be sent down to the Bureau of Motor Vehicles. And if you don't show that you had insurance, then you're subject to being suspended under a suspension called a non-compliance suspension. So you weren't complying with the law that said you have to have insurance. And that'll result in a suspension. And it'll require you to, and on the first offense, it'll require you to get what's called an SR-22 bond. So it's a bond that the insurance company provides, that the insurance company says to the state of Ohio, if this person who now has insurance doesn't maintain their insurance by paying the premiums, then we'll notify the BMV that they don't have insurance anymore and they'll be suspended. So most people who don't have the requirement for the SR-22 bond, the insurance company, if you stop paying your premium, won't notify the BMV because there's no responsibility on the insurance company's part to contact the BMV. But if you have this SR-22 bond, then they're responsible to contact the BMV, and then you'll be suspended again. So a lot of people are under these suspensions. And unfortunately, they bring themselves to the attention of a police officer somehow. And then they're charged with driving under suspension because the suspension has been put into effect. And the penalty for that is up to a fine of up to $1,000. And some suspensions, not the non-compliance, but some other suspensions, are punishable up to jail. So we deal with that all the time. And part of the reason for that is because police officers have the ability, when they go out and observe traffic, they have the ability to look at your plate. And in fact, there's some machines that will look at your plate and then provide that information to the police officer who's sitting in his cruiser. It'll go to his computer. It's a laptop that's usually sitting next to him, and it'll pop up who the registered owner of that vehicle is, and it'll provide a picture. And it'll provide information as to whether or not they're suspended or whether they have a warrant for their arrest. And the officer can then pull them over. Even though they didn't
do anything bad,
break the law, they didn't have a traffic offense, the law allows the officer to pull them over, determine whether or not that person who's driving is the owner of the vehicle. Many times it is. And then they can charge them with the driving under suspension as a result of that, tow their vehicle, and the expenses rise.
Yeah, it goes real downhill right away.
And so that person then is required to go to court and deal with the situation that they're in. And a lot of people are driving because they have to go to work.
Sure.
And they choose to take the risk, and unfortunately, they somehow come to the attention of a police officer. So that's the majority of what I see in Avon Lake. That's the majority of what all the judges in Lorraine County, and I'm sure throughout the state of Ohio, because I go to judicial conferences where there are judges throughout the state of Ohio who say the same thing.
I see.
Yeah, they have to deal with these driving under suspension offenses.
And with these automatic readers of driver's license, license plates on cars, I think you'll see even more of this.
Yeah, no, that's very true. Yeah, so one of the things we can do is try to help them get their license back, because a lot of these people are clueless as to what, because it's been so long since they've had a driver's license.
Yeah.
And sometimes, we print out for them when we know they're coming in, we know they're charged with the driving under suspension. We'll print out from the BMV website that we have access to the information about, the things that they need to do to get their license back, and I'll go through it with them, and I'll highlight it, and I'll number it. And so you do this first, this second, this third, this fourth, and they'll say, I didn't know that.
Yeah.
So I guess.
So you're helping them.
It's really a sense of I did something good today, and I've talked to other judges, and they feel the same way, that you can really help them because it's a burden that they carry all the time, and if you can lighten that burden and get their license back, it really makes their life a lot simpler. And sometimes I'm surprised they even made it to court. And sometimes they look like they just got out of bed, but I try to be sympathetic and understanding about their situation.
Yeah. Human beings.